Hello, everyone, and welcome to the webcast. My name is Christine Dorsey Davis. I'm the Executive Director of the Ohio Chapter, the American Planning Association, and I am your webcast moderator. Today is Thursday, November 12th. We will hear the presentation, Sign Ordinances. For technical help during today's webcast, you can type your questions in the chat box found in the GoToWebinar tool panel. And for your content questions related to the presentation, again, just type those in the chat box. We will answer those at the end of the presentation during the Q&A. Coming up next is a list of our sponsoring chapters and divisions for 2020. Thanks to all of those participating for making these webcasts possible and free to members. Today's webcast in particular is sponsored by the Mid-Atlantic Planning Collaboration, which is a joint venture of the Maryland National Capital Area, Virginia, and West Virginia chapters, along with the Maryland Department of Planning, Maryland Planning Commissioners Association, Rural Planning Caucus of Virginia, and West Virginia University's Land Use and Sustainable Development Law Clinic. The intent is to address topics that may be of interest to people involved in planning at all levels across multiple regions, and they have a series of sessions available. Up here on your screen is a list of our upcoming webcasts. This is it now through the end of 2020. We're already starting to book 2021 sessions. So that's exciting. Head over to ohioplanning.org/planningwebcast to register for all of our webcasts that are available. And you'll see here a list of all of our upcoming sessions. So be sure to head over there. Today's session has been approved for 1.5 CM law credits. So for those of you that need to log those AICP credits, just head over to planning.org, log into your MyAPA account, and from there you can either search by today's title or event number, both of which can be found in on our webcast webpage. Again, ohioplanning.org/planningwebcast. And I've been saying this now for about a week and a half. The CM search function has been a little wonky the last few weeks. So if you have trouble finding the session to log for credit, have no fear. It is available for credit. Just email me at info@ohioplanning.org and I will send you a direct link to log those credits. Like us on Facebook, just search Planning Webcast Series and we'll pop up. That's where I post any immediate information, like if there's a new session that you can register for, if we have a date change, which actually we did last week, or at the beginning of this week, we had some technology failure, so we had to reschedule a session. So I post any kind of information like that up on Facebook. And we also record all of our sessions and we post them on our YouTube channel, so be sure to subscribe to our channel. We have over 300 videos posted there. We have over 3,100 subscribers, so be sure to join us. Like I said, we record everything. And we also will have a PDF copy of the presentation available on our webcast webpage at the conclusion of today's session. Again, ohioplanning.org/planningwebcast. That is the end of my housekeeping items. So I am going to turn the controls over to Joe, Whitney, and LJ to get things kicked off for us. I've just sent those controls over to you.
Hi, and thanks, Christine. Yeah, as mentioned, excited to be here. I have two great presenters with us today, Whitney Morgan from WVU Law Clinic and LJ Bennett from the city of Frostburg, both going to be sharing some exciting presentations on signage and issues related to signage. So as Christine mentioned, excited for the session and a lot going on with APA and all the chapters, so excited to be a part of it. Again, I'm Joe Rogers. I work for the Maryland Department of Planning, and I am the regional planner for the Western Maryland region of the state of Maryland. So that includes Allegheny, Garrett, and Washington County. And I offer technical assistance to local jurisdictions and municipalities and counties. And in my day-to-day work, I work in many different areas. In my past work, I have done sign ordinance issues and zoning ordinance questions, so I am a bit versed in this subject area. So excited to hear what everybody has to say. And without further ado, let me kick it over to Whitney. And we were having a couple of technical difficulties earlier, so I'll be running her presentation for you. So I apologize if there's any missteps on my end. But again, thanks everybody for being here, and kick it over to Whitney. Thank you.
Well, welcome. Thank you everyone for being with us this afternoon. Thank you for the introduction, Joe. I'm Whitney Morgan. I'm a clinician with the Land Use and Sustainable Development Law Clinic at West Virginia University College of Law. In my role with the Land Use Clinic, a good portion of my work involves helping communities develop and update zoning ordinances, which has, of course, involved helping our communities understand how signs can be regulated. So I'll be speaking first generally. You can go back a slide, please. So I'll be speaking generally about regulating signage, and then our other speaker today is going to focus a little bit on historic signage. All right, so I wanted to first start out just by thinking, I'm sure about how, I'm sure many of you have encountered similar community questions or concerns in regulating signage, like, can we ban billboards? What can we do about Christmas decor left up year round? Can we prevent political signs from medians or public property? How can we preserve the aesthetics of historic areas? What is there to do about unsightly temporary signage? And then some of the heavier questions like, can off-premises signs be regulated differently than on-premises signs? Or can commercial signs be regulated differently than non-commercial signs? And then just for fun, there's some less common but newsworthy sign questions like, is there anything to do about those neighbors that painted their home as the American flag? Or can a person erect a 20-foot poster board of her favorite presidential candidate in the front yard? Or what is there to do about a business that posted anti-government window signs in every window of a business during eminent domain proceedings? Some answers are straightforward, some less so, and a few are inconsistently decided among courts. My goal today is to review how signs can and cannot be regulated, as much as that is currently resolved in the law, and to identify where unknowns remain. Hopefully with the result that it makes it a bit easier to issue spot when communities want to limit signage. So to start out, signage lies at the intersection of land use law and First Amendment protections of freedom of speech. First Amendment protections extend to signs, which are undeniably a form of expression. Signs pose distinctive problems, however. Unlike oral speech, signs take up space and may obstruct views, distract motorists, displace alternative uses for land, and pose other problems that legitimately call for regulation. But one of the most important things to first understand about regulating signs is simply, or maybe not so simply, what constitutes a sign. Next slide, please. There could be north of 400,000 billboards in the United States. Next slide. And we see even smaller signs. There is a wide range of what home occupation signs could be outside of someone's home, indicating that legal or real estate services are provided inside, salon services, small piano or dance schools, childcare, and even psychic readings. Next sign. I know we've seen a lot of these lately. Interestingly, they cost less than $1, so it's no surprise how much we see of them. And then there's this guy. Is he a sign? At over 20 feet tall. Or this, is this a sign? Next one. Or these. Next one. What about these guys? Are these a sign? And lastly, is this a sign? Next slide. The answer is all of those images depicted a sign. The definition the Land Use Clinic currently uses is the following. A sign is any device with the essential purpose to communicate, designed to communicate, or placed where context results in communication, and such communication is aimed at persons in a public right-of-way. Signage encompasses many things within a community, and communities justifiably want to regulate signage. That said, communities must be exceedingly careful in how they regulate signage, especially post-read. Next slide, please. In the summer of 2015, the Supreme Court of the United States held in Reed versus Town of Gilbert, Arizona, that sign regulation based on the content of the sign is subject to strict scrutiny analysis, which means in most cases that the regulation will be found unconstitutional. Specifically, the Town of Gilbert, back please. Specifically, the Town of Gilbert exempted several categories of signs from permitting, including ideological, political, and temporary directional signs, with each of the sign categories having different requirements on maximum size and duration of display. These provisions were found to be content-based, subject to strict scrutiny, and did not pass constitutional muster. As you can imagine, and maybe even upon reflecting on your own community's current regulations, the case made almost every sign ordinance in the country unconstitutional. I can tell you that relatively recently, 4 or 5 years post-read, I had students review 45 sign ordinances from around the country, and every single one of them contained unconstitutional content-based provisions, with political signs and flag regulations being the most common culprits. Broadly speaking, when I use the term content-based, what I mean is zoning laws that favor or disfavor certain messages, whether intentionally or unintentionally. In zoning, favoring or disfavoring certain messages might entail allowing more or less sign area, more or fewer number of signs, or exempting some signs from the permitting process based on the content of the message. Next slide. More specifically, sign regulations can be content-based in one of 5 ways, whether regulated based on a specific message, speaker, subject matter, function or purpose, or limited based on an event. The first and most obvious way for regulation to be content-based is by targeting the message of the sign. For example, an ordinance may not allow unlimited US flags within the community, but limit the display of other flags. Flags typically show support for a particular entity or cause, and allowing the display of some more than others favors or disfavors specific messages. A specific example from the 4th Circuit, Central Radio versus City of Norfolk. Under the local zoning ordinance, sign was defined as not encompassing any flag or emblem of any nation, organization of nations, state, city, or any religious organization, with the result being that many flags were effectively exempted from the sign code. This was held to be content-based, subject to strict scrutiny, and the ordinance violated the First Amendment. Next slide, please. The second form of content-based regulation occurs when regulation varies based upon speakers. An ordinance should not allow, for example, roof signs for churches, but prevent schools from also having roof signs. Roof signs could be a permitted type of sign only within certain zoning districts, but specifying which uses may utilize roof signs gives some speakers more speech than others. Next slide. Third, ordinances that allow more or less signage for different subject matter are content-based. So for example, an ordinance may not have different requirements for wicket signs based on whether the sign displays a message related to religion, real estate, politics, or garage sales. This is effectively READ. Wicket signs are a pretty commonly used form of temporary sign, and regulations should not specify different limits for displaying temporary wicket signs according to subject matter, such as a 3-day limit for garage sale signs, a 1-month limit for political signs, and unlimited display of real estate signs. Next slide, please. The fourth type of content-based regulations occurs when ordinances allow signage based on its function or purpose. So for example, an ordinance may not allow banners only for the purposes of announcing a new business or representing sponsors. Uses may want to utilize banners for many other functions or purposes. Next slide. Lastly, ordinances that vary signage based on an event can be content-based. So for example, an ordinance may not allow increased signage associated with a particular holiday, type of celebration, or an election. For instance, ordinance language that allows unlimited display of flags on Memorial Day and Veterans Day, or maybe more common, an ordinance that limits the display of wicket signs to 30 days before and 2 days after an election. In both of these instances, the amount of signage and thus speech differs based on an event and is likely unconstitutional. Next slide. Worth noting, some narrowly defined types of speech are not protected by the First Amendment at all. The most relevant type in the context of signage is obscenity. What constitutes obscenity is a bit complicated and involves application of both federal and state law, the details of which are well beyond the scope of this presentation, but still I wanted to point out that obscenity is not speech protected by the First Amendment. Next slide. So having gone through the many forms of content-based regulation of signage that should be avoided, believe it or not, there remain many tools for regulating concerns related to signs. The key is to stick with content-neutral regulations, otherwise referred to as the objective qualities of signs, which is what I'll call it in this presentation quite a bit, or time, place, manner restrictions. More specifically, what can be regulated is informed by guidance provided in Justice Alito's concurrence in Reed. This is informative, but not binding. Justice Alito said what could be regulated might include rules distinguishing between the placement of signs on commercial and residential property, rules distinguishing between on-premises and off-premises signs, rules restricting the total number of signs allowed per mile of roadway, rules imposing time restrictions on signs. Why local governments can regulate signs is similar to that of regulating through zoning at all. Local governments generally may enact zoning laws under the police powers for the purposes of public health, safety, and welfare. Certainly with signage, both public safety and public welfare concerns are at play. In terms of public safety, signs can be distracting or even dangerous to drivers and pedestrians, but they can also be helpful in locating destinations or navigating around town. Meanwhile, public welfare includes community aesthetics and resulting effects on property values. Signs can be unsightly, but they also have the potential to be inviting and pleasant to look at. An important note, even content-neutral sign regulation, but especially any content-based regulation, should make clear the governmental interest involved in that regulation in ordinance purpose statements. Ordinance purpose statements are often quoted in court cases in establishing what governmental interests were involved in regulating signage. One pretty comprehensive example from the Ninth Circuit cites the various governmental interests involved in San Francisco's planning code. And it says that it regulates signs for the purposes of promoting aesthetic and environmental values of San Francisco, protecting public investment in and the character and dignity of public buildings, streets, and open spaces, protecting the distinctive appearance of San Francisco, and reducing hazards related to imposed on motorists, bicyclists, and pedestrians. Also an aside, signs on public property are fundamentally different from signs on private property. Local governments have far greater authority as property owners and landlords than they do under the police power. Next slide, please. So what can local governments regulate? What does objective sign regulation look like? First and foremost, we can regulate the form or type of sign that may appear in each zoning district. Different types of signs are suitable for different districts, and some might not be suitable at all for a particular district. Picture, do you see monument, projecting, wall sign, chalkboard, geological, changeable copy, awning, teardrop? Any of these can be banned, including billboards, provided sufficient speech is afforded through other forms of signage. Materials can be regulated, particularly in terms of durability and quality. Landscaping can be required, such as within certain proximity to particular permanent signs. And lighting may be regulated in a number of ways. The type of lighting, whether internal or external, shielding, the time window when lighting may be used, and lighting can be allowed only with certain sign types if desired. Next slide. Certainly the number of signs may be limited per use, as can a sign's duration of display. The colors and fonts that can be used may be limited, as can the number of words per sign. Display features may be limited or prohibited. This comes up a bit with electronic signs, features like movement, motion, flashing, sound, and others. I've even seen smoke as a sign feature be prohibited. Maintenance and removal of signs may be regulated. Next slide, please. Some of the basics, the size and height of signs can be limited. The percent coverage of an area, such as a wall or windows, can be regulated. And certainly the location of signs can be regulated through setbacks and orientation requirements. Next slide. And as I mentioned, all of these regulations can vary according to the needs of different districts. In a residential area, you don't expect to see much in the way of signage, and limiting signage undoubtedly maintains residential character. In a downtown historic area, though, you might expect to see just a few small types of signs, like awning and projecting signs. As compared to more commercial areas, you might expect to see larger signs where they may just be more needed. No matter the district, however, sign regulations really should be uniform across the district. Next slide. In addition to content-based regulation, communities can run afoul of the First Amendment simply by restricting too much speech. There are two analytically distinct grounds for challenging the constitutionality of municipal ordinances regulating the display of signs. One is to discriminate on the basis of a sign's message. It's what I've discussed up to this point and will largely focus on in this presentation. But alternatively, speech regulations are subject to attack on grounds that they simply prohibit too much protected speech. In conjunction with the latter notion, voicing your opinion through a sign displayed at your home has been recognized as an important and distinct medium of expression, which is why in the city of Ladue versus Galeo, where the city banned all signage with few exceptions for residences, those being residence identification signs, for sale signs, and signs warning of safety hazards. The regulation violated the First Amendment simply for prohibiting too much speech. And yet, residential areas often have the most restrictions on signage. That said, it's important to ensure your sign ordinance does not prohibit all residential signs and should ensure that residents are afforded enough speech through signage. This likely means more than enough for a few political signs, which were at issue in Ladue, and a sufficient real estate sign. Oddly, real estate signs enjoy a special status because of a 1977 Supreme Court decision, Lindmark versus Township of Willingboro, which held that a local government could not prohibit real estate signs. Next slide, please. One particular type of sign warrants special mention. There are so many beautiful murals around the state of West Virginia. I do really enjoy looking at them, but figuring out how to regulate them is another matter. Thinking back to our definition, are murals a device with the essential purpose to communicate, designed to communicate, or placed where context results in communication, and such communication is aimed at persons in a public right of way? I have had a planning commission member look me straight in the eye and tell me that art doesn't communicate, which I found rather surprising. But many local sign ordinances provide exceptions for art or treat art differently. And what little case law we have on the subject of murals has struggled with exceptions made for art. This is in part due to the fact that it's difficult to articulate why one type of mural has more or less effect on traffic safety, and even more so, how one has more or less aesthetic effect or aesthetic value. Consider also that determining what constitutes commercial versus non-commercial speech is a fact-based inquiry. Making this determination is rarely simple, and courts may reach different conclusions, even in factually similar cases. And murals are a prime example of this. So some quick case examples of the difficulty courts have had with murals include, in one case, a bait shop with a marine-themed mural on the outside wall of its shop. This was considered non-commercial speech. A mural containing a bunch of happy dogs, one of which was a business's cartoon logo. That was considered commercial speech. A mural depicting a mad scientist with beakers and chemical molecules occupied by a business that sold racing fuel additives. Commercial speech. A toy store named Indoor Octopus, or Inland Octopus rather, with a large octopus mural painted on the back of the store. Commercial speech. And a convenience store with painted scenes of Mexican heritage. Non-commercial. Needless to say, the most prudent approach, the only constitutionally safe way to regulate murals, is to treat them as signs and regulate them with the same objective parameters. The land use clinic, we simply define them as wall signs. Now I want to come at this from another angle. Next slide, please. And next slide, please. So let's say your community is okay with the situation on the left, and essentially it has to be, but would like to avoid the disaster on the right. Certainly you have to be careful to avoid reference to political signs or elections. But what you can regulate are wicket signs. Their number, you can limit the total sign area allowed per use, the duration of display, removal of signs, and setbacks from roads. Next slide, please. Another example. Let's say your community is okay with Santa on the right, but not so sure about, for the sake of argument, a comparably sized billboard in the front yard. And both are right in front of a home. What you can regulate are certain types of signs. So inflatable signs versus billboards might be appropriate in certain areas. You can also regulate height and afford less signage for maybe permanent residential signs than temporary residential signs. Next slide, please. There's Santa and his message again, and Santa again with a less appealing message. Certainly be careful to avoid reference to Christmas or holidays, or even a window of time overlapping certain holidays, like the November to December timeframe. But what you can regulate are the duration of display, materials, the number of words, number of signs, maintenance or removal, and again, a limit on the total sign area allowed per use. Next slide, please. And then there's beacons. Why wouldn't a community want a McDonald's bat signal? Again, careful to avoid reference to Christmas or holidays. But what you can regulate are where beams are cast, whether onto a building or into the sky. Temporary, whether they're temporary in nature or allowed for a certain duration of display. and you can allow only in certain districts or within certain timeframes of the day. Next slide, please. Let's say your community is okay with what's on the left, but not so much what's on the right. By all means, be careful to avoid reference to art or artistic value, and certainly avoid reference to any specific message. But what you can regulate are materials, ceiling requirements, fonts, number of words, etc. And a couple more. Next slide, please. Let's say your community is okay with the sign on the left, but not so much the sign on the right. We at the Land Use Clinic have defined these as person-assisted signs. And what you can regulate are setbacks from roads and possibly limiting the proximity to these being utilized within certain feet of the entrance to a use. But it's more prudent to avoid reference to advertising and certainly to avoid reference to soliciting donations. Next slide, please. And lastly, let's say it's just a matter of too much sign area. You're okay with what's on the left, but would like to avoid what's on the right. You can limit the types of signs, but also get into the coverage of windows and doors and the number of signs. Next slide, please. So with as much clarity as Reed may have brought to the realm of sign law, there has been some disagreement regarding distinguishing between on and off premises signage and distinguishing between commercial and non-commercial messages. Cases that deal with these issues often deal with them in tandem, typically because off-premises signage is defined as involving commercial speech by local governments. Justice Alito's concurrence in Reed recall states that the on-premises versus off-premises distinction would be constitutional. Again, it's binding, not binding, but it's informative. And notably, historically, regulation of commercial speech has been analyzed under a less rigorous test, the Central Hudson test, applying intermediate scrutiny as compared to non-commercial speech, which uses Reed and applies strict scrutiny. A couple of recent cases are worth noting regarding on-premises versus off-premises distinctions and distinctions made between commercial and non-commercial speech. One comes out of the Fifth Circuit. The City of Austin defined off-premises sign as a sign advertising a business, person, activity, goods, products, or services not located on the site where the sign is installed, or that directs persons to any location not on that site. The sign code allows new on-premises signs to be built, but it does not allow new off-premises signs to be built. Ultimately, the court held that because an off-premises sign is determined by its communicative content, the sign code's distinction between on-premises and off-premises signs is content-based. Defining off-premises signs as those related to goods or services not offered on the premises where the sign is located is fairly common among communities. It's difficult to think how to otherwise articulate the difference between an on-premises sign compared to an off-premises sign. Another example comes from the Sixth Circuit. In a Tennessee case and similarly in a subsequent Kentucky case, the court reasoned as follows, that it's possible for a restriction that distinguishes between off and on-premises signs to be content neutral. For example, a regulation that defines an off-premises sign as any sign within 500 feet of a building is content neutral. But if the off-premises, on-premises distinction hinges on the content of the message, It is not a content neutral restriction. A contrary finding would read Justice Alito's concurrence as disagreeing with the majority in Reed, and the court declined such a reading. Justice Alito's concurrence enumerates an on-premises, off-premises distinction that is not defined by a sign's content, but by the sign's physical location or other content-neutral factor. This case found the Tennessee Billboard Act unconstitutional, and the subsequent case did the same for the Kentucky Billboard Act. So both the Fifth and Sixth Circuits have applied Reed strict scrutiny analysis to the commercial, non-commercial, and on/off-premises distinctions. But importantly, the signs at issue in Reed were non-commercial. They were temporary, directional, religious, political, and courts have since Reed stated that Reed leaves intact the general framework for evaluating restrictions on commercial speech in Central Hudson and for evaluating billboard regulation in Metro Media. Ordinarily, regulation of commercial speech is subject to a less rigorous test that applies intermediate scrutiny, not strict scrutiny. And that's what the Ninth Circuit did with the San Francisco case that I mentioned earlier. San Francisco made both of the distinctions between commercial and non-commercial and on-premises and off-premises signs, and applied Central Hudson's intermediate scrutiny to determine that neither was unconstitutional, at least as they manifested in the San Francisco ordinance. So in that case, commercial signs were treated less favorably than non-commercial signs. Non-commercial signs were exempted from the planning code and defined loosely by a non-exhaustive list that included official public notices, government signs, temporary display posters, flags, emblems, insignia, etc. The court applied Central Hudson since only commercial speech was affected by the code, and specifically rejected the notion that Reed altered Central Hudson's long-standing intermediate scrutiny framework. And then as to the other distinction, the San Francisco Planning Code also distinguished between on and off-premises signs, with off-premises signs being those that direct attention to a business, commodity, industry, or other activity sold, offered, or conducted elsewhere than on the premises on which the sign is located, or to which it is affixed, and which is sold, offered, or conducted on such premises only incidentally, if at all. Whereas on-premises signs were defined as those that direct attention to their primary business, commodity, service, industry, or other activity which is sold, offered, or conducted on the premises upon which the sign is located or to which it is affixed. The sign code prevented any new off-premises signs in San Francisco. Nevertheless, worth reiterating is that determining what constitutes commercial versus non-commercial speech is a fact-based inquiry. Making this determination is rarely simple, and courts may reach different conclusions, even in factually similar cases. Murals were a good example. Another oddity worth noting is that in the 11th Circuit, non-commercial speech may be considered on-site wherever it is made. And the argument for that is curious. An idea, unlike a product, may be viewed as located wherever the idea is expressed, that is, wherever the speaker is located. Under this view, all non-commercial speech is on-site. A sign bearing a non-commercial message is on-site wherever the speaker places it. I would ask to consider the consequences if zoning were not able to make a distinction between commercial and non-commercial speech in on and off premises signage. Any and all signage allowed per use, residential, commercial, non-commercial, and otherwise, could be sold to advertising. And that seems pretty disastrous for zoning. So to summarize, there are essentially 4 constitutional tests that may be applied to a local sign ordinance. If the sign ordinance distinguishes among different types of signs with non-commercial messages Based on the content of those messages, it is likely to be subject to strict scrutiny, under which the government will have the burden of proving that the ordinance serves a compelling governmental interest. Secondly, if the ordinance simply regulates the content of commercial signs, giving preference to non-commercial signs without distinctions among them, then the ordinance may be subject only to review under Central Hudson's intermediate scrutiny. Next, if the sign ordinance permits commercial messages where it does not permit non-commercial ones, or otherwise prefers commercial speech over non-commercial speech, it is presumptively unconstitutional, because generally speaking, non-commercial speech is more protected than commercial speech. Lastly, regulation of signs may violate the First Amendment simply by prohibiting too much speech, where foreclosing entire media or eliminating common means of speaking, sometimes something specifically of concern, and over-regulating residential signage. In closing, one of my former students gave me an extremely old children's book at the conclusion of her time with the clinic titled Signs Everywhere, which frankly has become a bit of my existence just by the nature of my job. If you didn't notice signs everywhere before this presentation, you may find yourself doing so moving forward. My apologies in advance. Signs are everywhere and they have a profound effect on the look and feel of our communities. It's just essential that we understand how they can be regulated, or at the very least have a sense for how to issue spot and address our concerns. I'll be happy to answer any questions at the conclusion of Ms. Bennett's time.
All right, and thank you so much, Whitney. That was just action-packed and information-filled. As Whitney did say, we will be doing the Q&A at the end, so I'm going to quickly switch over to signs and sign regulations in the Historic District, and that presentation again is by LJ Bennett, who is the Community Development Director for the City of Frostburg. So, without further ado, I'll introduce LJ here and take it away.
Thanks very much, Joe. Thanks, Christine. Thank you, Whitney. And thanks everyone for joining us here today. As Joe introduced me, I'm LJ Bennett. I'm the Community Development Director for the City of Frostburg. As such, I am staff support for our Historic District Commission, and I assist in the application, meeting, presentation, and approval process. I also oversee the permitting of signs for the City of Frostburg. Next slide, please. We come across some unique issues in the Historic District, and that involve our zoning signage regulations. Electronic message centers are an important topic. Lighting, height, brick and mortar, and color are also other very important topics that we come across when we're looking at signs in the Historic District. Frostburg's Historic District is on the National Register of Historic Places, and as such, it follows the Secretary of the Interior standards for rehabilitation. And those standards that are related to signage primarily focus on the preservation of the historic character of the district. The City of Frostburg's Historic District Commission has also adopted their own guidelines as well to provide recommendations to citizens who are looking to make exterior alterations. Again, the focus is on the preservation of the historic integrity of the district, and staff can help citizens when they arrive with an application to help them understand what's recommended and what's not recommended in the Historic District. Electronic message centers are not permitted in the Historic District, much of which is along the Main Street business district in our town. So here's an example of a changeable copy sign. It's also lit up at night with gooseneck lighting from above. Here's another example of a painted sign band with raised lettering and gooseneck lighting, so it can be illuminated at night. Next, we have some examples of brick and mortar inlaid lettering. On the left, you see the Frostburg Business Center inlaid in the mortar of the brick above the sign band, which also identifies the two businesses located in that building. And on the right, you see a proposal for inlaid lettering for the Frostburg Museum. Attaching lettering to brick and mortar facades can be done in the historic district, but it's crucial to preserve the brick and the mortar. This is where technical preservation services and their preservation briefs come in handy. Particularly, preservation brief number 2 is in regard to repointing mortar joints in historic masonry buildings. Properties of mortar are really important when you're going to repoint, because historic mortar is not the same as modern mortar. So quite often what's required is a mortar analysis so the historic mortar can be recreated. And I've left the link there for you for that particular preservation brief, but there are many that are incredibly helpful in historic districts. Next slide, please. Our local zoning ordinance regulates sign height in all districts of the city, but importantly in the historic district where we have downtown shopping areas. The regulations limit size, projection, and placement, as well as height for pedestrian safety. Here's an example of a projection sign in our historic district. It identifies a boutique. It's safely above the walking area of pedestrians who may pass below it, and its size is rather small because it needs to fit under that awning, and it falls within the sign regulations and was approved by our Historic District Commission. Color is another issue, and this may vary across municipalities, but in Frostburg in particular, our Historic District Commission does not stipulate colors, but it does request that colors for signs come from the manufacturer's collection of a historic palette. And the next slide just shows some very basic examples of historic palettes. Almost every paint manufacturer that we can find here in the United States has a historic palette. Finally, here are just some resources. I know we went over these pretty quickly, but the National Park Service has the historic preservation standards for rehabilitation available. The National Park Service also provides technical preservation services that I noted are very helpful, and as well the National Register of Historic Places. And of course, I would always recommend that everyone look to your local zoning ordinance in terms of sign regulation and any historic preservation overlay that may impact those decisions. And there's my contact information in case anybody wants to reach out to me. And thanks again for this opportunity. It's been a really informative webcast. Thanks again.
And thank you, LJ. That was great as well. I think now we're going to kick it back over to Christine for the Q&A portion of this, and then we will throw our contact information up on a slide here for everybody to see. That way, any direct questions or specific ones can be directed to either Whitney, LJ, or myself for anything general. So yeah, that's how, this time I'll just turn it over now to Christine, do the Q&A.
Yeah, we definitely have questions. Again, folks, don't use the raise your hand function. Be sure to use the chat box, type those questions in, and we'll see how many we can get to. Okay, so the first question, we'll start with Whitney on this one. In terms of signs that may have obscenity on them, can you comment on whether it should be handled as a zoning matter or should it be handled as a police matter? And I guess you could say that perhaps I'm going to add to this and say not just obscenity, but I guess any type of signage or any words that might be considered kind of vulnerable to anyone?
I'm not sure I can comment on which way it should be handled, except that insofar as zoning is going to offer an opportunity to fine the individual that's violating the ordinance. I know that our zoning laws issue daily fines between $50 and $500. It may be another, deterrent, but that's the limit of my understanding of dealing with obscenity.
Okay, thank you. Next question. Can an HOA limit the use of real estate for sale signs?
Well, a homeowners organization or deed restrictions are, I suppose the easy answer is that I can't imagine that any mechanism is going to successfully be able to wholly prevent individual homes from having a real estate sign on their specific home. But I'm not sure that I have enough understanding of how First Amendment protections might vary when speech is limited through private actors versus government actors. There may be a meaningful difference there, and I'd have to look into that more.
Okay. Another real estate sign question. In your opinion, can there be a time limit, such as 6 months?
Absolutely, but not specifically for real estate signs. It would have to be the form of real estate signs. You can have a time limit on wicket signs or H or U-shaped signs, or however it is that you define the form of sign on which a real estate sign will manifest. But it cannot be a time limit specified for real estate signs. I think that's exactly what Reed said, and many other cases have said.
Thank you. Generally, do county governments, school boards, state agencies, so government in general, do they need to follow municipal sign regulations?
I've gotten that question many times. So there's a couple of components to that question. One is, I think that it matters where you're located, whether or not the state has to follow local zoning ordinances at all. That is going to be determined by where you're located. It gets a little tricky with signage because there's a difference between public and private lands and government speech versus private speech. And I basically need an hour-and-a-half long session to sort through all of that. Probably the so signs on public property are fundamentally different from signs on private property. So local governments have greater authority as property owners and landlords than they do under the police power. I'm sorry, this answer is not a great one, but I think on the whole, you can't, you shouldn't exempt your local government from the sign ordinance language, but you can still understand as a local government that on public properties, you have a different level of say in what goes on because you own the land. Now, there's more caveats about picking and choosing speakers and having permitting processes before speakers can place things out, because then there's concerns with prior restraint. I mean, it's a very complicated question.
Okay. Let me try to find you a less complicated one this time. Could you comment on street signs for historic districts?
Should maybe Ms. Bennett?
Yeah,
address
we'll let LJ take that. Give Whitney a break anyway. She's, needs a water break. So
I'd be happy to comment on street signs in historic districts. That's definitely something that would fall under the sign ordinance and would be evaluated as such. There are residential areas within our historic district that have opted to erect signage that identifies that area as the historic district. And they're put through review just like any other sign in the historic district would be. And as long as they meet the regulations and the standards, they're welcome.
Okay. This one could be for either one. For communities wanting to update their sign codes, do you have a model ordinance that you recommend?
Absolutely. I really like the one at the end of the zoning and land use controls treatise available on Lexis.
Wonderful. Whitney, does allowing some signs like flags, wicket, etc., to be allowed without a permit, while other signs like building signs, monuments requiring permits create some kind of constitutional issue?
Whether or not permits are required, whether or not it is the same as a size requirement or a time limitation or anything else. That's an objective difference in signage. So long as the permitting is based on the form of the sign, like whether it's a flag or a billboard or a wicket sign, it should be fine. It's the same thing. You could have even a permitting scheme that didn't apply to minor signs defined as those signs less than 4 square feet. So long as the permitting, the difference in whether the permitting is required or not is based on an objective quality of the sign, it's fine.
Okay, thank you. In that kind of same vein, is a distinction between permanent and temporary signs still valid, or would that be deemed invalid constitutionally?
It's completely fine to differentiate between permanent and temporary signs. What gets difficult for communities is that historically, particularly with temporary signs, the types of temporary signs have been enumerated in ordinance language. So you'll have, temporary signs, and temporary signs are defined as real estate signs and birthday banners and opening business, yada, yada, yada. And it's that definition of temporary signs that's a problem. If you define temporary signs as signs erected for less than 30 days, or signs that are, by form, there's certain forms of signs that are typically temporary in nature, wicket signs, banner signs, there's others. then that should be fine. It's just that you have to be careful with the definition of temporary sign as being limited to form and time constraints, not as relating to any particular subject matter or an event.
Okay, thank you. A clarification question. Wicked signs, it's not wicked like W-I-C-K-E-D, it's W-I-C-K-E-T. Could you give a definition of what that is? Because there's a couple folks that don't know what that means. So it's W-I-C-K-E-T is what you're referring to.
Yeah, wicket signs. They're just the H or U shaped temporary signs that are often utilized to put up a real estate sign or a political sign.
I think we're about to see one. I feel like Joe just got up.
It's just those little signs that you stick in the grass.
Like that. Yeah. So it's W-I-C-K-E-T sign.
Yes, ma'am.
That's just what they're called. So for those that, there were a couple folks that had a question saying, why are you calling them wicked? Why, what is this? Okay. Next question. Let's talk about billboards for a while. Let me go up and grab that question, the first one. How do cities deal with mobile billboards and the ever-changing location for some of them?
Wow, that's a good one. Well, I'll answer as best I can. So, my experience is primarily limited to land use law, and mobile billboards are functioning on roadways, which is really, I mean, and if they're moving on the roadways, that's outside of what zoning is going to deal with. That said, my understanding is that, I mean, you first have to have authority to regulate mobile billboards, and it might not be inherent in zoning. If they post up somewhere and stay there for a period of time, I suspect zoning would address it. But insofar as they're just moving on roadways, that's mostly outside the realm of my experience. And I can tell you in West Virginia, we don't have some kind of authority to regulate those individually. I know that they have been an issue in several places around the country, and that attempts to regulate them have been problematic, but I'm afraid that's the extent of my knowledge.
Okay, this is a good one. Can a building be considered a sign? So for example, a building shaped like a hot dog and bun for a hot dog restaurant. And how do you measure that one?
Yeah. How do you do the area? Yeah. For
Right.
the permit fee. One hot dog plus bun, I guess the square footage would be X. Yeah, no, that's, yeah. I mean, that's a really good one. That probably would come up a lot in bigger cities, definitely, because I mean, I would think it, Whitney, what's your opinion on that? I would think it would count as some sort of a sign, but I don't know what exactly you'd permit it as or what it would be considered.
Well, for starters, you'd want to look at the definition of sign in your particular ordinance. I think that, and under the one that I included in the presentation, I think it would be a sign. But at the same time, you know, when you allow signs within your community and you list the different forms of signs and whether they're temporary or permanent and how they're allowed, et cetera, I'm curious I mean, the building being a hot dog probably is a sign, but whether or not it's a sign allowed within your communities, you're going to have to look at the particular ordinance. I can't think of any definition of sign that I've encountered that would encompass a building shaped like a hot dog. I mean, luckily zoning is largely enforced on a complaint-based system, so you'd have to have a pretty sophisticated, upset neighbor to make it an issue. But yeah, I think what that gets at is this difference between, one of my coworkers loves to sort of pick on me and say, are Christmas lights a sign? Because, you know, maybe context and placement communicates something. And I don't exactly know the answer, except that I would argue that lights are lights. And if you go down that rabbit hole, then is your pumpkin on your front porch a sign? And, you know, any other object that could be found or that, you know, rotates on your front porches around your neighborhood, could those be signs? And I don't know exactly where the line is between decor or lighting and a sign. And that giant building shaped like a hot dog, maybe you could just say it's hot dog decor. But thinking back to the mural cases where they painted portions of exterior buildings with objects that might not even necessarily have been a logo, but were, you know, related to what's inside. You know, some said yes, those murals were commercial in nature, and some said they weren't, and maybe there's a similar distinction between what's just pretty and what's a sign.
Okay, next one. Here we go. How about, how do you deal with vehicles that could be operated but nonetheless stay in one place? So for example, in my town, there's a Chick-fil-A and they have a pickup truck with Chick-fil-A written on the side of it, and there's a giant blown up cow that just sits in the trunk, or, you know, in the bed of the truck. And it just sort of sits at the corner of the road. I mean, that's clearly a sign, but I know for a fact that it's, you know, not registered as one. What are your thoughts on that type of thing?
Well, I mean, I think you're right. It's definitely a sign. We have a definition that would cover that particular one, and it's signs attached to vehicles that are inoperable or that, you know, stay in a certain position on a certain property for a period of time. And, you know, for that one, it's just anticipating the issue and drafting to address it.
Okay, next one. Let's see. This one will be for LJ, I think. I'm trying to find it. Here we go. Historic district signs. Besides the signs mounted on the front facade of a building, does your ordinance address other types of signs in the district, such as murals, billboards, political signs, temporary signs with bright colors? Can you go into a little bit of detail?
Sure, it does. So the traditional types of sign bands and mounted lettering all fall within the parameters of the ordinance. Political signs are permitted. We don't regulate political signs at all. Temporary signs quite often are composed of vinyl lettering that's manufactured in such a way that it's almost like peel and stick. And it can go on the inside of a window to identify a business or It could be a logo, it could be anything. And we don't regulate those either because we consider them to be of a temporary nature. Other signs, perhaps like yard sale signs, real estate signs, we don't really touch real estate signs, but temporary signs and banners that advertise something's for rent, a business space is for rent, or there's a yard sale happening somewhere, they have a lifespan of 30 days. They can be put up to 5 days before the beginning of the event, and then they can be in place for 30 days, and they have to be removed after the event. So that's generally how we regulate temporary signs. Were there some other examples there that I didn't address?
Murals.
Murals, we have several murals in town. We don't regulate those, but they're considered public art. And, you know, often we may have a grant in place, something to that effect, where we can solicit artists to make a presentation to us, and then there's the decision-making process goes from there. I'd be happy to share our sign ordinance if anybody's interested in looking at it.
And if for those that have any questions about regulating murals or things like that, we actually had a webcast a couple weeks ago in September, and it was called Public Art Life Cycle, and it is available to view, and it's all about the legalese of public art, including murals. And there was we had a good discussion about murals. There's been a couple of those webcasts, so take a look at our previous webcasts if you're interested in more information about that. This one's interesting. They're having a situation with excessive signage. There's a homeowner that has more than 10 no trespassing signs on their property, and folks around them are getting a little ticked off. So what do you recommend? Can we limit something like that? I would suspect that someone made that person perhaps angry and they felt the need to put up that many signs, but obviously it's excessive. Thoughts on that, on those no trespassing signs?
Well, ordinarily, signs required by law or safety signs can be exempted. You know, that's a content-based distinction, but I think they can be exempted. The no trespassing sign doesn't exactly fit within that, but I don't know the law behind the right to erect trespassing signs and the details of it. So I wouldn't want to foreclose whatever ability the landowner would be entitled to have to communicate no trespassing. I mean, it doesn't sound reasonable. And I imagine it largely depends on how your ordinance is drafted. There may be nothing to do about it. It's probably not a satisfactory answer.
No, I'm sure it's not for them, particularly for, I'm sure, the other residents that are giving this person an earful. Okay, well, it is what it is. Let's find another question here. How do you not regulate political wicket signs while not getting overrun with commercial wicket signs?
In the city of Frostburg, we definitely regulate off-premise and on-premise signs. So we don't get overloaded with commercial wickets all over town because commercial businesses must advertise on their own property.
Right, and I think that was largely the point I wanted to make for the circuits that have said you can't make that on-premises, off-premises distinction based on the activities of the property, is that the result is where you're trying to afford appropriate non-commercial speech to landowners and your community, that doesn't mean that you are at that same level allowing businesses to speak everywhere. And so, I mean, legally, it seems like you can still make those on-premises, off-premises distinctions. I think there's a very reasonable, logical argument tied to basic zoning premises of, you know, what's accessory to the use. It's not accessory to a homeowner to advertise with their private business that's located somewhere else. But it is accessory to that use, I think, to express their political beliefs and stuff. And so I just, yes, it matters the on-premises, off-premises distinction that's largely going to be tied to whether speech is commercial or non-commercial. That being said, just to reiterate, having distinct requirements for political signs, identifying the word political signs anywhere in your sign ordinance is unconstitutional. That word should never appear, nor should the word real estate signs. You can identify them only by form, temporary in nature, etc.
Okay, next question. Do you consider moving signs to be a safety concern, and wouldn't zoning's police power apply?
I haven't seen any case law to suggest that there's any limitations on a local government's ability to limit sign features like movement and motion and differentiate between them. I mean, certainly anybody's welcome to look at our model sign ordinance as well, and we have different levels of electronic sign definitions, whether they're static, partially involve some kind of partial movement where the sign changes in a period of time, versus fully animated. There should obviously the police power and the interest in safety and even aesthetics can affect whether and to what extent those electronic signs are allowed within a community.
One more clarification question regarding our lists of regulations in historic districts. How about lettering on storefront windows? Do you have guidance on letter font specifically? So LJ.
Definitely. Our local guidelines include recommendations for the type of lettering, the shadow cast on the hand painted lettering. It's very specific in terms of recommendations for that.
Thank you. And how can folks get a copy of the ordinance?
Well, I can give it to you. Is there a way to?
Do you have a link? Is there a link that we can send out to folks?
Sure, I'd be happy to provide that.
Okay, wonderful. Oh, this is an interesting question. This one just popped up. What about school video boards for their fields? Are those considered signs?
I've gotten that one and a similar one with sponsor banners all over the exterior of ball fields and stuff. And I mean, that I think largely hinges on the last part of our definition, which is that, is it aimed at persons in a public right of way, or is it just incidentally viewable? And I would say for the purposes of zoning, no, it's not a sign. It's meant for the ball field. That's its word. So.
Okay, how about this one? Corporate building designs, such as like McDonald's, Taco Bell, Pizza Hut, you know, where you don't even need to see a sign to know what kind of build, or, you know, what's inside of that building. Could those technically be considered signs? Have you seen any case law on that?
So I just want to make sure I understand the question. Buildings are readily recognizable because of their exterior design. Can that be itself be a sign?
I think that's what the person is asking. Yes. The
Yeah,
designs
like,
themselves,
yeah,
are they a
I
sign?
think, yeah, because they have to stick to that like that model, and it's almost like weird when you see another business try to come in afterwards, and you've seen that. I've seen like a business try to come into a Pizza Hut, and you're like, what's, a furniture
Right.
store doing in a Pizza Hut?
Right.
And
Or
it's
those,
like, well,
the
it's not a Pizza
old
Hut
Taco
anymore.
Bells. I know,
Yeah.
you see funny things. You're like, that doesn't,
Mhm. Right. But I mean, technically, wouldn't that be a new business, new use? I mean, even though the building does look iconic in a certain way, what it's used as, can be different, but I don't, that's a tricky one.
Well, I mean, in part, it's going to depend on your community's definition of sign, and thinking about the one we use. I mean, it is broad enough where maybe technically you could make an argument for that, but I have not seen, I mean, sorry, I haven't seen any case law suggesting that like that the design of a building facade can just generally be recognized, is just generally a sign.
How about something that's clearly signage, but is only viewable from an aerial view? So for example, if someone painted signage on a roof, and maybe you can only see it from an airplane, or if it's lower in elevation and a highway is up high enough where you could look down and see the roof, is that technically considered signage?
I have no idea whether the sky is considered a public right of way. I thought I'd heard it all. I have heard
We stumped
sign.
you.
Yeah. I mean, I've addressed signs that are flown by airplanes over a community, or signs that are driven by boats, past a highly populated area. It's similar to the mobile billboards. I maybe I don't. I have a hard time. Well, because of okay, local governments can regulate for aesthetic purposes, and for safety purposes. I don't know. I'm gonna have to think about that one more, because I'm not sure like the relationship between caring about the few random people that are up in the sky versus the community members that you're ordinarily considering.
This question: what about when your state department or transportation department regulates the placement of political signs specifically along state maintained roads? Is that a thing? Is that a consideration? Have you heard of any issues with that? Where their regulation trumps?
Well, the Highway Beautification Act is riddled with content-based distinctions, and insofar as states have basically copy-pasted it, it's again riddled with content-based distinctions. There's at least one state, I can't recall off the top of my head which one, that has argued that the reference to advertising and such is fine. But the fact of the matter is, in my opinion, that all needs overhauled. You cannot make content-based distinctions. The word political sign may not appear in regulation. It's just so abundantly clear that's the case. The reason why we're having this conversation 5 years after Reed is that sign regulation at the federal level, state level, and basically every local government in the entire country had that in their ordinance, and most of them still do.
Okay. There's a couple questions similar to this one. I'm going to kind of mesh them together. Let's just say that there's a store or a restaurant that has awnings and they put either their logo or the name of their company on the awnings. Is that considered signage?
Well, I mean, we have that as a defined sign type. So in our communities, yes, and I mean it's a permanent device that communicates. I think that's a pretty straightforward answer. And if you want to regulate it, just make sure that you have definitions that encompass signage that's placed on awnings.
Okay, I think we have time for one more question. Let's see here. Going back to the HOA again, there are a couple of these. What does an HOA or the town municipality have final say on signs within a subdivision?
Well, I mean, that's probably going to be fact specific. I frankly don't know the limitations. I don't understand. I'm not. I'll have to look into that one. I don't have a good answer.
Okay. So we're going to get everyone, I know, Whitney, you mentioned a good model code that is your go-to. And LJ, you have a link that you'll provide me for your code, for your ordinance. So I'll be sure to have those available on our webcast webpage. And we are recording the session. It'll be available on our YouTube channel. Just search Planning Webcast. And we'll also have a PDF copy of this slide deck available on our webcast webpage again, ohioplanning.org/planningwebcast. So thank you to Whitney and LJ and Joe for joining us today, and for the Mid-Atlantic Planning Collaboration and the Virginia chapter for sponsoring today's session. This was great. Don't forget to log those CM credits, and be sure to visit our webpage, ohioplanning.org/planningwebcast, to register for more of these sessions that are within this program, and also the rest of our sessions that we have available through the end of this year. So everyone, thanks for joining, and have a good rest of your week.
Thank you. Same to you.
Thanks.
Thank you.